other batch of things that are exemptions are prior statements by the witness. There's a really easy way to understand this. Alright, what you need to understand about the admissibility of any prior statements by witnesses under this rule is that before you even consider the A, B, and C under this rule, you have to establish two things. That the declarant of the statement is testifying at the trial or the hearing, one. And two, that that declarant is subject to cross-examination. So, for your purposes, since you guys are limited to how many witnesses you can call, and there's always more witnesses in the packet than everyone can call, it may not qualify as an exception or an exemption to hearsay if that particular if the declarant of this statement is never called. We clear on that? There are two threshold requirements to even using this rule. First and foremost, that person, the declarant of the statement, needs to be present, and second, subject to cross-examination. For your purposes, if you get one, you get both. Because if a witness testifies, they always get crossed.
It says that they have to be subject to cross-exam concerning that statement. So what if they were crossed in the prior trial, hearing, whatever, but they didn't touch on the statement that they're trying to elicit? Does it get in under that exemption?
Hold on one second. Does it qualify under the exemption if they have not been subject to cross concerning that statement? Probably. Because the line is really not whether or not the question concerning the subject matter was asked, but rather whether the cross-examining attorney at that point could have and maybe should have asked about it. It's not really like, if you're trying to get in now whether or not someone said that the ball was blue in the deposition, and they were talking about everything under God's green earth except for what he thought the ball was, the statement's probably going to come in because he was subject to cross at that time, and it's just, the attorney didn't ask. That doesn't mean that it shouldn't come in if that witness actually made that statement before. Okay, so these are the two threshold requirements for using prior statements by witnesses. There are three kinds of prior statements by witnesses that one would use this rule for. Alright. Inconsistent statements, consistent statements, and statements of identification. 801 D1A is a very, very, very useful rule. Marco, what does 801 D1A do for you? Practically speaking. Right, right. This is the rule that actually allows you to impeach someone with their entire deposition or a statement that they made in an affidavit out of court. If you really think about it, whenever you approach a witness on cross-examination about something that they previously said, you're always getting into hearsay testimony, right? Because it's always out of court. There are always statements that were made out of court, and they're being offered to prove their truth. Except when you're talking about inconsistent statements. Think about it for a second. If you're talking about an inconsistent statement, why is that going to be, why would that make sense? Why does it fail under this definition of the rule? If you're trying to admit a witness's inconsistent statement, Why does it fail under one of these three parts of the definition of hearsay?
Because it's not out of, one of those statements is not out of court, it's in court.
No.
That's not offering the truth of that.
Yeah.
What's the purpose that you're offering it for?
The truth of their statement.
Well, actually,
Proving that they lied.
The truth
one
that
of
they're a
two
liar.
times.
Yeah.
Yeah, it's inconsistent.
you're not offering it for the truth, you're actually offering it for the completely opposite purpose, to show an inconsistency in their statement. The way this pans out is witness A is on the stand testifying that the chair is pink. But witness A also testified in a deposition before the trial that the chair at the time was blue. So on direct examination, witness gets up there, beautiful direct. At the end, what color was the chair, by the way? It was pink. First question on cross-examination is, you previously testified that the chair was, this wouldn't be the first question, but you would spring right into that impeachment. You would confront them with that statement, and you would basically bring up that inconsistency. At one point, you testified that the chair was blue, did you not? They'd have to cop to it. What are you doing, though? Practically speaking, evidentiarily speaking, you're getting their hearsay testimony in, right? You're asking them statements that they made that are out of court that you're now offering, not for their truth, but to show an inconsistency in them. Very, very powerful rule. The corollary to that rule, the rule that's closely connected to that, I guess it's the antagonist to that rule, is 801D1B, which is what allows you to offer consistent statements. Now there's a gloss to that, that always remember that these two rules work together. You never have an opportunity to use this one unless you use this one, because of the language of the rule. The rule says that, and I'm looking at 801D1B, consistent with the declarant's testimony, and is offered to rebut an express or implied charge against the declarant of recent fabrication. Really what it boils down to is, alright, on direct you got up, same fact pattern, direct you got up here, said the chair is pink, on cross they got up here and impeached the witness and said that the chair was blue, then they get up here and they say, alright, have you ever said before, other than these two times, have you ever said that the chair was pink before? Yeah, I said it was pink 37 times before that. Alright, what you're doing is trying to rehabilitate your witness after the impeachment. It's not, why would a consistent statement in this scenario not meet that definition of hearsay? Basically what I'm asking you is, are you offering the consistent statement for its truth now?
No,
What's the purpose that you're offering it for?
for the rehabilitation, or to show that the witness isn't a liar, or they're more credible than
Credibility.
they looked.
Basically that's the argument. It's a fine line because it sounds like you're arguing that, sounds like you're arguing the truth of the statement, but you're really arguing the truthfulness of the witness.
Which in and of itself is the truthfulness of the statement.
Not necessarily. Because, I mean, I could be a truthful person and I could lie.
Right.
Or I could be a liar and be telling the truth.
But the reason your advocate would be redirecting you on a given impeachment is because that particular fact would be important and the truthfulness would be vital.
Is it so much better to improve the credibility of the rest of the testimony?
It has to do with the credibility of, well, I mean, I guess it does have a lot to do with the credibility of the testimony in general, but specifically, the reason why you are allowed to do it and the reason why it doesn't logically violate this rule is because the purpose of you offering a consistent statement under this rule is to rebut an express or implied charge of recent fabrication. Under this rule, when the words express or implied charge of recent fabrication, that just means an impeachment. That's all it means. To rebut an impeachment. Think about it. Express or implied charge of recent fabrication. In other words, sorry about that. In other words, the crossing attorney just got up here and called my witness a liar. I'm now offering other consistent statements by this witness to rebut that impeachment. That's really all it does. So these two subsections work together. Understand them together. They're opposites of one another. They're reactionary. If opposing counsel does this, you're allowed to do this. Clear? Really? Hell of a teacher. The last one. Or one of identification of a person after perceiving the person. I saw him. That's really all it means. You guys know that really exciting part in a trial when, I'll use the same example as I did before. You got this old decrepit woman. A gross old woman. I mean, she wears moo-moos, and she's got big glasses with like the thing that hangs around her neck so that when she gets up to eat her prunes and everything, she doesn't lose her glasses. All right, so this woman's she's just gross, and she's nosy too. So she happens to look out her window across her street, and think really cheesy here. Like, you know, there's like this big bay window at this house across the street, and the lights are on the inside, but there's a curtain, so you can't really see inside. But what you do see is shadows, and you see, and she comes to court and she testifies, I saw this action going on behind the shadow, and then like I saw this going on behind the curtain. So the question proposed to her after she lays out that testimony is, who was the person that you saw going like this? Well, she testifies, well, it was the defendant. Why is that admissible? It's admissible because she lived across the street, and assume that these facts would have came in direct. She saw this guy before. She's been able to identify him so well that she would be able to tell that it was his silhouette. Shaky testimony at best, but it proves the point. She had already perceived him. So now she's allowed to identify the person based on her perception. Now keep in mind that it still qualifies under this rule, because at some point before trial, she would have had to have been asked the question in a deposition, or maybe just made it to a police officer. She would have had to have said, to have any role in this trial, it was my neighbor from across the street that was killing his wife. Excuse me. So she made that statement of identification after perceiving the person, and it's now admissible. Why is it not offered for a truth?
Why?
I don't know.